Hello. Welcome to the podcast today. This is Ralph's Law, where justice reigns. This video is actually part of it's like a continuation series on my, it's about litigation. So, this will actually help a lot of attorneys. It's just things that they probably know already, but it's just reminders, So today, in my last video, I was talking about opening statements and how you're supposed to do the opening statements, but don't ask for something very big from the jury. Give them a soft pitch and then just basically let them know that the evidence will lead them to a position where they will ultimately just rule in your favor or in the favor of your client or whoever you're representing. So that's what I wanted to say in that video. But in this video today, this is all about cross-examination. Now, cross-examination is kind of funny because I've seen a lot of attorneys mess it up. Now, you can have a bad case, a case that's actually not going very great. But if you do, you can actually save the whole situation by doing a very successful cross-examination. And there are just like some subtle skills that are involved in that. And, these are some of the skills, some of the tips that I've seen people mess up. If you can do this, if you can actually have this on the top of your mind, you will be really great in cross-examination. Okay, so one of the first things that you actually have to think about as an attorney is, do I really need to cross-examine this witness? Yeah, so hold on, just think about it, because sometimes some attorneys actually think that they have to just say, hey, I have to do this cross-examination. Maybe you don't have to. If the person is not going to contribute anything that will actually advance the success of your case, you may not necessarily have to cross-examine the person. So sometimes it may actually it may actually be more advantageous for you to just hold on and say, hey, Your Honor, I don't have to do any kind of cross-examination with this witness. Leave it alone. I know, I know. So, attorneys, sometimes we find it difficult to shut up. So that's what I'm trying to just put out there. This would actually help young attorneys. It will also help some experienced attorneys, because sometimes they actually don't get it's kind of like the other aspects of the game. Okay, this is Ralph's Law, where justice reigns. Okay, I try to keep it real here. If you haven't done so already, please subscribe, like, comment, and share. All right. Out here, we give you the information that is actually designed to just improve your life in every which way. And if you're an attorney or you're a law student, we just want to get your litigation skills to get to the next level. All right. So look at it this way. Do I need to cross-examine this person? If I don't need to, I should just shut up. Let it go. But if I need to, then I can also I can then go to the next level. All right. Some attorneys don't know when to shut up, and actually, like they get it all mixed up. Okay, so that's what you as attorneys, and litigators, you have to have that in mind. Okay. Another thing, I've seen that some attorneys do this. Do not try to embarrass the witness. Do not try to embarrass or humiliate the witness. I know, people watch like Perry Mason and all that stuff where, like somebody just gets the witness to confess to something bad. Don't do that. Just don't do that. As much as possible, try to keep it cordial and, just like decorous, do not, just so understand that the court, typically, every court, they respect decorum, do not engage the client, the witness, and start being quarrelsome with the witness. That's not gonna be in your favor or in your client's favor. That's what I'm trying to say. So don't do that. It's not necessary. And it's like, I mean, what do you get from that? I mean, at the end of the day, it's all about outcomes. So if you think about it, what kind of outcome do you want to get? You can battle with the witness or whatever, and then your client loses the case. I mean, what did you achieve? You know, so that's what I'm trying to say. Don't do that. All right, just don't do that. Now, we're gonna get to the next step. This video is a bit different because I actually had a lot of colleagues of mine that wanted me to do this video, and I've had people that have actually been practicing law for a while, but some of these things, it doesn't come as second nature to them. So, you know, as you guys already know, I'm an attorney and I'm also a law professor. So it comes more naturally to me, but for some attorneys, it may not actually come natural to them. So that's why I want to do this video and just put it out there. All right. So that at least, if nothing else, it would actually be some kind of helpful reminder to some attorneys on what not to do when you're representing a client. So, one of the things that you're not supposed to do is the kind of questions that you ask in cross-examination. Do not ask open-ended questions. Open-ended questions. So do not ask questions that will actually give the testifying witness some kind of opportunity to explain stuff. Don't do that. So the way that you can actually maintain control of the cross-examination process is by asking only leading questions. I mean, you guys already kind of know this, you know. I mean, you know, if you went to law school, you kind of understand the whole thing about a leading question. You know, you probably did that in evidence. You know, a leading question is generally a question that prompts or encourages the desired answer. That's a leading question. In cross-examination, that's what you need. A leading question can also be called, you know, AKA suggestive interrogation. Okay? Suggestive interrogation. That's all you need to use in a cross-examination. I mean, this is crazy. I've actually seen even experienced attorneys mix it up and they start asking ridiculous questions like, oh, tell me what happened on this date. You know, explain this whole thing to me. No, you're not supposed to do that. And that's what I'm trying to say. I'm trying to give attorneys, even the ones that have been practicing, I'm trying to give you guys just you know, a bit of a suggestion, tips, roadmaps on how to do this stuff. Signposts. There are stuff that you shouldn't do. Leading questions all the time. Do not ask open-ended questions. What, how, where? Don't ask that. If you do that, you're losing control of the whole situation. Okay? Cross-examination is supposed to be the attorney, you, the cross-examiner, and the witness. You know, so you call the shots. Once you start asking questions that will make them explain a whole lot of stuff, you've actually lost control at that point, and you shouldn't be doing that. So a lot of attorneys, they actually mix it up. So no open-ended questions, okay? Leading questions only. So leading question is like, sometimes like, it's pretty much, you can make a statement and then you put in a word like correct. So Michael, were you at the 7-Eleven? Michael, you were at the 7-Eleven yesterday, right? And the response to that should be a yes or a no. That's it. And that's how you want to do it. Don't mix it up. Leading questions in cross-examination. That's it. That's how you do it. When you do that, you'll actually have a better control of the whole situation. Okay, so that's just how you do that. Another thing that I've seen some attorneys do, they don't listen to the answers that are actually provided to them. Listen to the answers that is coming from the witness, because sometimes you can actually get an answer that will actually be good for your case. So your ability to listen to the answer and be able to use that to actually advance, and further vindicate the cause of action for your client is actually very necessary. Sometimes attorneys, they talk a lot and they don't listen. Communication skills, you have to understand being able to listen. So when you ask the question as an attorney, shut up and listen to the answer that the witness is giving. And that's what I'm trying to say. Okay, so yeah. So this video is just it's a bit different. I will actually do another part of this video just to tie this whole thing together. But just understand, listen to the answers that the people are giving to you. Okay, all right. So that's just how it is. And do not argue with the witness. Do not. It doesn't matter. Even if they're being they're being like hostile or whatever, try as much as possible to not argue with them. And if it gets so badly, of course, you can always tell the judge that the witness is being non-responsive, but don't argue with the witness, because if you're doing all that stuff, the jury is looking at you like, oh my gosh, and it kind of signifies that you have lost control. So don't argue with the witness. No, it doesn't matter. Another thing that you can do, you can ask your question again, restate your question and say, hey, you haven't answered my question and I'm gonna ask the question again. So the jury is looking at that and they're seeing that you're doing great, but do not, do not argue or get into some kind of quarrelsome match with a testifying witness, okay? Now, finally, the last thing is, you have to emote. A lot of attorneys, even some experienced attorneys, they don't emote. If a witness is just saying something that's a lie, be expressive in your face. Emote. That's it. That's very necessary. Okay. So, all right. Let's just leave this here the way it is. This is Ralph's Law, where justice reigns. I will do a part of this video later on and complete the whole situation, but cross-examination key to a successful lawsuit or a successful outcome to whatever you desire for your client or whoever you're representing, okay? Thanks very much for your time. Ralph's Law, where justice reigns. I will see you soon.